बाकी वो पिछले हफ्ता Bismillahirrahmanirrahim. Assalamu alaikum. Today's our topic is law of industrial relationship. So, see the overview of this. We discuss history, system, structure, collective bargaining, challenges, changing trend, political affiliation. First of all, industry relations. Industry relations are the efforts made for the resolution of the difference between employer and employees on objectives and values, profitability, sharing and social justice, discipline and authority, freedom, industry democracy, collective bargaining, cooperations. That are Lester's RA 1951. History of industrial relationship pre-independence era. Pre-independence era. At the time, there were only two major important laws by British rules: Employer and Workmen Dispute Act 1860. Indian Factories Act is 1890, 1881, sorry, it's 1881. After the First World War, strikes by the labor were reached at the highest rate of era, so they resulted in the creation of two important. The first, the Indian Trade Union Act 1926, and the second is the Trade Disputes Act 1929. The Industrial Dispute Act is 1947 was made in Amjad A and Mahmood K 1982. After the partition, Pakistan implemented many industrial legislation development rules by the British rule. For example, Factories Act 1934, Trade Union Act 1926, Industrial Dispute Act 1947, Industrial Employment Act 1947. आफ्टर पार्टीशन पाकिस्तान जो है ना, उन्होंने ये जो है इम्प्लीमेंट किए थे. So till the 1952 in Pakistan, industry relations were not very strong, and there were no proper rules in law in the country. Canland 2007. Then on 15th August 1955, first government policy was made after the independence. ठीक है, 1955 में हमारी गवर्नमेंट ने पहली पॉलिसी बनाई थी आफ्टर द इंडिपेंडेंसी के बाद. Policy was approached to the General Ayub Khan in 1958. Next year of 4th February 1959, second labor policy in the country was made, named as a Burki labor policy. This policy allowed the government to direct involve the negotiation and the conflict resolution between the employers and employees. Later in letter, Bhutto saw this as an opportunity. He made a People Labor Federation Shah 2010. General Zia in 1977 again imposed the martial law on the country. During the Junaid's government, they got some rights to be rights, and ban was partial lifted. Still, most of their activities and powers were banned. In 1989, in the first turnover of Benazir Bhutto's ban on his trade unions was completely lifted. After that, in Nawaz Sharif and Benazir Bhutto government. In 2002, the General Musharraf, for the start, his government made some very strict law to limit the activity of the trade union. For example, it's the Industrial Relations Ordinance 2002. Beside this other anti-labor law and policies were made. ठीक है, अब उसके जो है बाद जो है पीछे ये भी जो है एंटी लेबर्स लॉ भी बने और पॉलिसीज भी बने लेबर्स के लिए. Then the later on the Gilani regime, some reliefs was given to the employees and Zulfikar Ali Bhutto policies were followed. Government also announced the Welfare Fund Ordinance, Employees Old Age Benefit Act, Amendment Industrial Relationship Ordinance, which enhanced the protection of worker. All these policies and ordinance are followed till now. वो सारे ordinance, वो सारी policies अभी तक follow की जा रही हैं जो 2002 में बनाई गई थी और अब वो continue है, अभी तक उनको follow किया जा रहा है. System of Industrial Relation. In Pakistan, IR are more common in the public sector as compared to the private sector. IR जो है वो बहुत ज़्यादा जो है implement किया जाता है किसमें public sectors में. During the past 15 years, it's been noticed that the average number of members in any trade union are 135 per union. In the September 2005, there are the 2005 three affiliated union by the International Confederation of Trade Union (ICFTU) merged into the Pakistan Worker Federation (PWF) and become a big unit. Unions use collective bargaining approach to resolve their conflicts with the employer, influence the government legislation through the strike and other activities. Dawn 2005. The law of Pakistan allowed the employees and employers from the union according to Industry Relationship Ordinance Act of 2008. Law also allowed to join the umbrella organization to the trade union to raise their funds and influence the government and employers. The formation process of union. The formation procedure structure is published in the Pakistan Labour Gazette, provides all the data related to the industrial analysis, know of strike, number of trade union and employer union, number of CBAs in Pakistan. System of Conflict Resolution. PIRO, Pakistan Industrial Relation Organization, Ordinance 2010 provide the detailed system of collective bargaining to resolve conflict. In the case of any conflict, the party who's having trouble has communicate their other through the worker council established with the establishment under the 12th section of PIRO 2020 or 2010. It's not 20, sorry, it's 10. At the first stage of bilateral negotiate takes place to resolve conflict within the 10 days. Then in stage 2, if the negotiation failed in the first stage, the party who is having a problem has sent a notice for the strike or locked out within the 14 days, and the party also send a notice for the appointment of conciliator by the provincial. Now this stage is conciliator appointed by the government to the resolve the problem and collective the bargaining. At this stage of conciliator prepares a document which is called a memorandum of settlement, and and it is sent to the both parties and conflict to resolve. At arbitration stage, at this stage, conciliator tries to convey both parties to agree upon the arbitration. If both parties in conflict are agreed for the arbitration, that when within the 30 days conflict has been resolved. ठीक है, अगर दोनों पार्टीज उस आर्बिट्रेशन पे इस एग्री हो जाती हैं तो वो जो कॉन्फ्लिक्ट है, वो जो उनका मसला है, वो रिजॉल्व हो जाएगा 30 डेज के अंदर अंदर. Award of arbitration will be finalized at the stage in the availed for 2 years period of time. But if the parties are not agreed upon the arbitration, it's agreed with party can go for the strike or lockout. ठीक है, अगर parties agree नहीं हो रही तो उसमें जो अगेंस्ट पार्टी है, जिनको कॉन्फ्लिक्ट है, जिनको मसला है उस चीज से, वो स्ट्राइक या लॉकआउट की तरफ जाएगी या जा सकती है. At the fourth stage of the collective bargaining, the party who is arising the dispute has to submit an application of the labor code for the final judgment and the legal procedure. If the lockout strike is longer than the period of 30 days, it's the cause of serious harm, it's helpful and peace of the society, federal government and fair interfaces. It can refer the NIRC or a labor court of the early resolution dispute. Now the labor court are directed to resolve the conflict within the 30 days. Challenges in the industry relations. Trade union income is a very low, which restrict their activities. Then a federal system of the country, labor code bribes, military rule. Many major group of the employees are not allowed to become a member of the any trade union. Privatization, CBA, collective bargaining agreement, status policies. CBS stand for that. Upcoming trend and changing characteristics of a workforce in Pakistan, that is the globalization, awareness of rights, ILO, introduction to program, decent employment objective in UN. ठीक है, उसके बाद आ जाता है population of Pakistan is increased faster as compared to job opportunity. Now the trend is changing and the government of Pakistan and is more concerned to create a decent job for labor force. The unemployment rate of the youth increased day by day. Day by day, the employment rate of a female had a decrease over the last 20 years and unemployment is increased for a male. The increase in the labor supply is directly affecting the wage rate. The government is making policies for the labor as it's increased the wages rate by the 16% and make this price a minimum wages. In 2006, the Labor Market Information and Analysis Unit was established, which has accepted accepted the international rules for labor and providing them current information. The policies are made to fill the gap between the supply and demand of labor. For the procedure, there are a proper cycle having a four step. The first step is formulation, then implementation, after that monitoring, and in the end evaluation. ILO, International Labour Organization. The International Labour Organization was created in 1919 as mean to promote the social progress and overcome social and economic conflicts in the interest through the dialogues and corporations. It's a unique tripartite structure brings together worker, employer, and government, and that gives them the opportunity to search for a common rules, policies, and behaviors from which all can benefit. Yeah, we can say that it's beneficial. The work on a gender equality is a highlight nowadays, especially for the right of women. The special facility must be given to the women so they can work even after the marriages. In 2010, the government introduced a new labor policy for the rise employment generation and to shield the right of the employer. The technical education and the vocational training authorities in Punjab is managing 49 technical education institute in 318 training centers and develop the international accepting program of study, system of examination, and the documentation system. The work is also being done on the right of labor child. ILO defined the minimum age for a labor child is 15. Minimum age, not matlab below than 15 year nahi hogi. For a proper evaluation of employment pattern and their evaluation over time, it is recommended that the GDP series of established so that is contribution of each sector to the provincial economy can be estimated. After that, the structural political affiliation and a problem of trade union in Pakistan, the nationalization of industries and other economic activities in the early 70s helped the growth of trade union and registered the union increase from 708 in the 60s to 2000 to 2552 in the 70s and 6,551 in the 80s, respectively. Today's about the 8,000 trade unions are listed in the public and private sectors. Decline in the union membership is massive privatization and downsizing. In the crew process, privatization, downsizing, and detachment that can take place over the last 10 years, more than 5 lakh workers lost their jobs and are living below the poverty line. Authorism and military regulation. Pakistan has been controlled by the military for most of its history. The control of the military has spread in a various sector in the current political emphasis of Pakistan is largely in the manifestation of the deep penetration of the army and civilian affairs. In the past year, registration is quite a number of a trade union has been cancelled, such as a Pakistan International Airlines, just like it's our PIA, Karachi Electric Supply Corporation, KESC, etc. These are the examples. There has been popular increase in the province of Balochistan, where more than 100 trade union activists and member of the Civil Secretariat Employees Association (CSEA) have been arrested. Political parties often fail to represent the interest of the common people and more often than not either the being of pressure from a local business interest or the agenda of foreign powers than local and national concern. Child labor is common and the result from a combination is severe severe poverty, employer greed, and inadequate of enforcement of law intent to control it. Child labor is a working in the traditional framework of a family farming or small business of employment of a child labor in the larger industries. Also, widespread child labor is a widely employed in the carpet industries must of which is family run. ILO on the range of program with the goal of eliminating child labor is encouraged the establishment of the Independent Child Welfare Foundation designed to rehabilitate child laborers and overseas child labor free certification program. The Constitution of Pakistan guarantees women fundamental safeguards. One survey of women in Lahore showed that we are engaged in sewing, embroidery, food preparation for the markets, stringing, flower assembling, plastic toys for other assemble work. Only a tiny fraction of these women are in the trade union movement. छोटे छोटे कामों के लिए जो ये women से ये trade union में include हो रही हैं. Now, what is the unfair labor practices? UPL. What is the unfair practice labor practices? The Federal Services Labor Management Relations Statute, the statute of the protect federal employees' right of the organized bargaining collectively and the participant in the labor organization of their choosing to refer the doing to choosing to refrain from doing so the a so ULP conduct by the agencies or unions to the violent violates right कहाँ गया? Violates right that the statute protects are the rules that is established. You can find more details information about the various ULPs and filling the responding of ULP's charge on ULP resources या ये websites हैं आप यहाँ पर जाके ये दोनों आप इसकी इन चीजों को और डिटेल में देख सकते हैं. You must visit this website. Employees' right. Employees' right. Employees covered by the statute have a right to the firm, join or assist the union or refrain from such activities without a reparsal, including the right to organize or attempt to organize a union in the workplace, act of the union representative, seek union assistance, file or pursue a grievance, refuse to form, join and assist a union, be fair represented by their union. Okay, बेटा file or pursue a grievance that means mistake, आपकी गलती. Agency ULPs, an agency commit a ULP when it's violates right that the statute protects. Example include threatening an employee that her career would not go much further if she proceed with her grievance. Transferring an employee okay. Transferring an employee to the undesirable job because she filled a ULPS charge, eliminating employees compressed work schedule without giving their union notice and opportunity to
मैम
bargaining.
बिल्कुल वॉइस नहीं आ रही.
आ रही है मैंने तो वॉइस को बहुत माइक को बहुत क्लोज रखा हुआ है. हेलो अब आ रही है?
Yes, ma'am.
Okay, beta, thank you. Refusing to grant an employee request for a union representative during an investigatory interview when the employee reasonable, fair, and disciplined. यूनियन यूएलपी, यूनियन कम इन यूएलपी, अच्छा ये सॉरी ये स्लाइड हो गई है। ट्रेड यूनियन मूवमेंट इन इंडिया, ठीक है, ये मैं उसका इंडिया का एग्जांपल लेके आई हूँ क्योंकि स्टार्टिंग में हमारे पास भी यही चलती थी। The trade union movement emerged in India basically as a reaction to the state of interventionist or a state of pluralism model. The economic reform packages emphasis on the privatization, liberalization, and Australian measure. Employee separation, okay, discharge a permanent separation of an employee from the payroll and in a violation of company rules or inadequate performance. Dismiss is यहाँ termination by way punishment. Suspension क्या होता है? Series of punishment generally awarded after through the inquiry. Resignation on the ground of health, illness, retirement age of superannuation, layoff or reattachment. Sorry, retrenchment. उसके बाद आ जाता है डिसिप्लिनरी प्रोसीजर, आप किस तरीके से कौन कौन से डिसिप्लिन के फॉलो करेंगे, ठीक है। ये है मिसकंडक्टिंग इम्प्रॉपर बिहेवियर बैक्ड बाय द रॉन्गफुल इंटेंशन, absence from a duty, LI labor, doing personal work during office hour, assault on the superior officer, act on the dishonesty or fraud, willful disobedience sorry, of a lawful order of transfer, drinking at the place of work, playing card at the place of work, ठीक है। ये क्या है? ये जो है उनके डिसिप्लिन के अगेंस्ट जाके अगर आप ये काम करते हो तो फिर ये उस एक्ट के तहत आपको पनिश कर सकते हैं। जाहिर की बात है आप जिस ऑर्गेनाइजेशन में हो उनके रूल्स आपको फॉलो करने होते हैं। अब ये यहाँ पर है, ये चार्ट देखें, शो द कॉजेज नोटिस चार्ज शीट, ठीक है, रिप्लाई नोटिस चार्ज शीट वालों की रिप्लाई आती है। अगर सर्टिफिकेशन, ये इन्वेस्टिगेशन के बाद ही आता है, अगर सर्टिफिकेशन रही है या नॉट सर्टिफिकेशन, अगर सर्टिफिकेशन रही है तो ठीक है। उसके बाद अगर आप सेटिस्फाई नहीं है तो उसके ऊपर इंक्वायरी होगी, रिपोर्ट करेगा फ्रॉम इंक्वायरी ऑफिसर जो उसके ऊपर बिठाया जाएगा, शो कॉजेज ऑफ प्रपोजिंग पनिशमेंट, उसके बाद उसकी रिप्लाई आएगी। अगर वो उस रिप्लाई में आपको सेटिस्फाई करता है, कंडोन करता है ये, तो उसको आप क्या करोगे? कंडोन करके वार्निंग दे दोगे। लेकिन अगर आप सेटिस्फाई नहीं होते, जो ऑफिसर है वो सेटिस्फाई, जो इंक्वायरी कमेटी बैठी है वो सेटिस्फाई नहीं होती, तो वो क्या करेगी? उस एम्प्लॉय को क्या करेगी? इम्पोज करेगी पनिशमेंट। उसके बाद है यूज पेंशन पेंडिंग इंक्वायरी इन केस ऑफ मेजर मिसकंडक्टिंग। ये तब होती है जब कोई इसमें यूएस पेंशन में कोई अगर कोई गड़बड़ होती है, कोई मसला होता है तो उस पर ये होती है, लेकिन ये मेजर कंडक्ट होती है। लेकिन ज्यादातर ये जो पनिशमेंट है ये केस रारली कोई होते हैं, अदरवाइज इस केस पे फोकस किया जाता है। Domestic inquiry, okay, whenever an employee is thought to be punished, it is usually for the employer to conduct a departmental DE for the purpose of finding out whether the proposed action of punishment is warranted. The procedure of holding an inquiry may be laid down under the SO service rules of the established or by mean of the awarded settlement, if no such a procedure specify principle than natural justice. प्रोसीजर क्या है किसका? डोमेस्टिक इंक्वायरी का। अपॉइंटमेंट ऑफ इंक्वायरी ऑफिसर, नोटिस ऑन इंक्वायरी, इंटेंशन कहाँ गया, intention of proceeding by the inquiry officer, procedure of leading evidence by the employer, and material evidence, examination of witness. Labor Law Factory Act, a Bible governing all the major labor law. पुरानी जो गवर्नमेंट है यहाँ उसके बारे में ये बात कर रहा है। All the major labor law जो है वो फॉलो करती थी उसके बारे में। This act was basically designed to protect the children and provide a few measures for the health and safety of the workers. Registration and renewal of factories. Employer to ensure a health of worker pertaining to the सेफ्टी मेजर वेलफेयर मेजर उसके बाद वर्किंग आवर्स आ जाते हैं स्प्रेड ओवर टाइम आ जाता है कौन कितना ओवर टाइम कर रहा है ये सारी आ जाती हैं ओवर टाइम्स ऑफ अडल्ट ठीक है एनुअल लीव एंड वेजेस ये सारी बातें इसमें आ जाते हैं लेबर लॉ ऑफ फैक्ट्री में उसके बाद आ जाता है ये इंडस्ट्रियल डिस्प्यूट एक्ट 1947 to secure industrial peace and harmony by providing a machinery and a producer for the investigation and settlement of industrial disputes by the negotiation instead of by all trial of strength through the strike and lockouts. The legalization is calculated of ensure social justice to both employers and employees and thereby the promote of industry progress. Then strike and lockout 14 days उसका टाइम पीरियड है वो उतना दिया गया है ले ऑफ 7 days and replacement 3 months closure 60 days उससे ज्यादा इनकी टाइम लिमिट नहीं है. The Industrial Employment Standing Order SO X 1946 जो हमने लास्ट क्लास में डिस्कस किया था define the term and conflict or condition of services between the employer and his employee include medical examination and AIDS case and aid in cases of accident identification of workmen and issues of identify card. Working time of the different categories of a workman record of age qualification and experience of entry exacts in liability for security checking shift working and the weekly of attendance and the late coming method applying for the different kind of leave and extension of leave action to unauthorized absence HR. The Maternity Benefit Act in 1961, no woman worked during the 6 week immediately following the day of their delivery or her miscarriage. No woman does any arduous work during the period of 10 weeks from the expected date of delivery. 12 weeks leave of which not more than 6 weeks shall proceed to the date of her expected delivery. The benefit to be paid average rate of wages for the 3 months preceding her maternity leave. In case of miscarriage, 6-week leave with pay at the same rate of applicable maternity benefit. The Minimum Wages Act 1948 and the Act of Preventing Labor and Exploitation of Labor require the central and state government to fix minimum rate of wages in the certain in certain scheduled employment. Minimum wages fixed reserved from the time to time duties of the employees to maintain the registered wages in showing wages payable actually amount of paid attendance to overtime reduction for the EPS, ESIs and other than net amount paid data of payment and signature of the respective employer. Payment of wages Act. In Act is regulate the payment of wages to the certain classes of person. Responsibility of person wages rests with the employer. Employer to fix wages period, no wages period shall exist 1 month. Deduction of wages, PS, ESI, insurance, fitness et al. The Payment of Bonus Act 1965, an act to provide the payment of bonus of person is certain establishment on the basis of profit, production and or productivity. Employers whose salary wages does not exceed rupees 10,000 per month, minimum 8%, 8.33% of salary wages and maximum 20% of salary Yeah, or wages can be payment. You can give the bonus. Contract labor regulation and abolition. Okay. Abolition. Act of the regulation employ of contract labor prevent exploitation of the contract labor and for the abolition contract in the labor certain areas. Okay. They are the statutory obligation to provide the minimum wages act payment act and payment of wages, provide provident fund and miscellaneous provision act ESI. The payment of bonus act etc are the fulfilled by the contractor in respect of his employed engaged. If not, the principal employer of the of the comply with it aimed recover and the amount paid contract employee or PF slash ESI or other authorities behalf of their contractor from the कॉन्ट्रैक्टर लेटर ऑन. ठीक है, ये डिपेंड उसमें होता है कॉन्ट्रैक्टर पे. The Appearance Act in 1961 applies to those appearance who are undergoing appearance training and design trades. From time to time, the central government has specified the design trades placement and training officer with the suitable qualification. Payment of stipend are the rate not less than the prescription minimum rate. ठीक है, जो आपको आपसे इंटर्नशिप और ये ट्रेनिंग करवाते हैं, ये उसकी बात कर रहा है कि पेमेंट ऑफ स्टेपन जो रेट होता है वो नॉट लेस देन प्रिस्क्राइब मिनिमम रेट होता है, फिर वो जितना भी फिक्स हो. नॉट टू पे ऑन टू बी बेसिस ऑफ पीस वर्क, not to require to the take a party in any output, bonus or other initiative scheme. Health, safety and welfare provision under the Workmen Compensation Act. The Workmen Compensation Act 1923, the Act provide for the payment of compensation to the work injured during the course of employment or the contract by any occupational disease peculiar to that employee for an accident resulting in the death, and the amount of equal 50% of the monthly wages is decided to workmen multiplied by the relevant factor. For a permanent total disablement in the amount of equal to 60% to the monthly wages of injured workmen multiplied by the relevant factor. उसके बाद है permanent and partial disablement according to incapacity of cause. Temporary disablement is rupees 2,000 per month up to a period of 5 years. Employee State Insurance Act 1948 provides for a health care and cash benefit in the case of sickness, maternity, and employment injury. Employees contribution 1.75 of wages, employees contribution 4.75 of wages. प्रीमियम जो होते हैं वो एम्प्लॉय खुद अपनी वेजेस और सैलरी से पे करते हैं इंश्योरेंस का. मेडिकल बेनिफिट, सिकनेस बेनिफिट, मैटरनिटी बेनिफिट, डिसेबलमेंट बेनिफिट, डिपेंडेंट बेनिफिट, funeral expenses, old age and rehabilitation, ये सारी एम्प्लॉयड स्टेट ऑन इंश्योरेंस है, उनमें ही आ जाती है. सेल प्रमोशन एम्प्लॉयज कंडीशन एंड सर्विसेज एक्ट. ठीक है, सेल प्रमोशंस पे भी इनके कंडीशन और एक्ट होते हैं. 1976 का ये फॉलो कर रहे हैं हम. एंड द एक्ट ऑफ रेगुलेशन सर्टेन कंडीशन ऑफ सर्विसेज सेल प्रमोशन एम्प्लॉयज इन द सर्टेन एस्टेब्लिशमेंट इन द फर्स्ट इंस्टेंस इंगेज इन म्यूचुअल इंटरेस्ट और क्या हुआ. Provides for the application to certain acts such as the Workmen Compensation Act 1923, Industrial Dispute Act इसमें आ जाता है. 1947 वाला मिनिमम वेजेस एक्ट आ जाता है. मैटरनिटी बेनिफिट आ जाते हैं इसमें. पेमेंट बोनस एक्ट आ जाता है. पेमेंट ग्रेजुएटी आ जाती है इसमें. द सेल प्रमोशन एम्प्लॉयज, ये सारे एक्ट्स इसमें आ जाते हैं. Employment exchange, compulsory notification of vacancy. To provide for the compulsory notification of vacancy to the employment exchange before filling up any vacancy, to prescribe to the notify the vacancy to such employment exchange is made the prescribed time limit to notification of vacancy selection at least 15 days before the applicant will be interviewed or tested. Employer to the furnish the result selection within a 15 days. Grievance handling. A grievance is a sign of employee discontentment with the job or his relationship with the colleagues. Grievance generally arise out of the day-to-day working relation in an organization, in employee or a trade union protect कहाँ गया? Against an act or policy to the management that they considered violating employees' right. One of the effective method is to have an open door policy. Could also be settled through the conciliation and abbreviation adjudication. ठीक है, उसमें वही कंसीलेटर वाले और एजेंट वाली बात होगी जो ये मसला सॉल्व करेगा. Employer recognition involves taking measure to encourage employees to the remains in the organization for a maximum period of time. If a person is not satisfied by the job he is doing, he may be switched over to some other more suitable job in today environment. To be the become very important for the organization to retain their employees. Employees empowerment entailed to identify how much responsibility and authority of individual can effectively handle without becoming over the burden or distress. Important turnover cost over the leads of more turnover, regaining efficiency, losses of company knowledge, interreputation in the customer services. Employees engagement in organization productivity is measured in a term of expectation, but the employees are said to be engaged when they show a positive attitude toward the organization and express a commitment to remain with the organization. How it could be implemented, provide a variety, conduct the periodic meeting, conduct the periodic meetings with the employee to commit to communicate good news and challenges of easy to understand company financial information, provide the open environment, get to know employees interest goals, stress source, etc. Celebrate the individual team organizational success. एम्प्लॉय कंसोलिंग. ठीक है, अब इसमें क्या हो जाता है, काउंसलिंग, इट्स काउंसलिंग. एम्प्लॉय काउंसलिंग इज अ डिफिकल्ट बट चैलेंजिंग फंक्शन इन द ह्यूमन रिसोर्स ऑफिसर दैट इज guide employed to their job. Counseling when used to correct will, they are guide to employ their job. Counseling when used the corrective will prevent a disciplinary action or even the termination, reduce the turnover and association costs, show the employer that